We've got a big story for you right off the top involving Kyle Rittenhouse, the young man, 17 years old, accused of murdering two people in Wisconsin, was in a courtroom today fighting extradition because he was in Illinois. That's where he lives. So he was trying to get his attorneys to stop the state of Illinois from sending him to Wisconsin to face those murder charges as an adult. And as we sit here right now, he is now in Wisconsin, in custody in Kenosha. Ryan Jenkins from our affiliate WTMJ was in Illinois earlier today in Lake County and has this for us tonight.
In court, the state of Illinois said their only job was to prove that all of the documents were in order to properly extradite Kyle Rittenhouse back to Wisconsin to face his charges. Attorneys for Rittenhouse argued the teen should not be extradited because the criminal complaint that charges Rittenhouse with the crimes was not signed by a proper magistrate in Wisconsin, which is required by law. Inside the courtroom on the 8th floor of the Lake County Courthouse, Rittenhouse sat silently. The chants of protesters down on the street could be heard. Outside the courthouse, these dueling protests, those who believe Rittenhouse should face his charges in Wisconsin, right up against those who think the teen's charges should be dropped. What does justice look like today?
What does it look like today? Extradition until the process continues. The process is flawed and broken, but we're here to fight to see it through to the end.
I believe the charges should be dropped altogether because self-defense is not a crime.
And again, the headline tonight, he was extradited. He's back in Wisconsin. Let's bring in Court TV anchors Ted Rowlands and Michael Ayala. Great to see you both tonight. That's the big news. This was an extradition hearing. You know, usually we don't even cover these things, you know, because most of the time they're waived. They're not fought. This one was fought. And Michael, you know, I used to make fun of criminal defense attorneys when they would try to break out the old technicality defense, but that's what was going on today, right?
Yeah, that's what was going on. And you know, I think there was a larger plan here to keep Kyle in Illinois as long as possible. Again, as you said, these extradition hearings always end up the same way. So the defense attorney files the motions. He's able to stay in Illinois, be near his mom for as long as possible before he ends up back in Wisconsin. And you're right, it was a technical issue. Let me point this out for you quickly. I think we have a full screen about the habeas petition. Basically, it said the extradition documents are deficient because A, there is insufficient evidence that the complaint was supported by an affidavit made before a magistrate, and D, the arrest paperwork contains false statements and is missing the required signature. The statutory requirements for extradition documents are not empty formalities. And so at the end of the day, the judge looked at it and decided that the papers were fine and we're sending him back to Wisconsin. And as you said, as of right now, he is in Kenosha, in jail, in custody of the sheriffs.
Ted, you know, I think there's more to this whole equation here. Yeah, there's the legal defense, there's the battle in court, but it seems that the state is saying the defense is trying to wage its war, yeah, in the courtroom, but really more in the court of public opinion with a lot of potential jurors and politicians who are watching this one.
And potential donors. People have already contributed to Kyle Rittenhouse's defense fund. This is a classic case where you either see it one way or another. Many people see a 17-year-old who doesn't live in Wisconsin armed to the hilt with a rifle showing up looking for trouble. Others look at the video and say, oh, this is a guy who's exercising his Second Amendment right. And he was attacked on the streets and he was absolutely using self-defense. It is one of those, you're either on this side or you're on this side. And it seems so clear when you're either on either side. And I think there is some validity to that the defense wants to keep this up in the public eye because it is one of those controversial cases.
And it's one that breaks down on you know, political perspective. It's very consistent. The way the nation is split, the way Wisconsin is split, you know, the way they're looking at this, that's the way the jury could end up being split in a case like this. And I think a lot of what they're doing, I agree with you, Ted, is playing to potential jurors out there to, you know, to let them know, hey, this is what this case is all about. Michael, this hearing I thought was going to be a mini trial because we had this extensive witness list from the defense, including experts on self-defense, experts on what it's like to be in prison, and Kyle's mom. But in the end, nobody testified. What's going on?
What's going on is I think it was just a ruse from the beginning. Again, just trying to extend the time that he is in Illinois or was in Illinois near his mom. Because even if he would have called the mom, for instance, why would the defense attorney want to give away information? If she gets on the stand and testifies about anything, then she gets cross-examined. Of course, she could be a witness in the case in chief in Wisconsin. He would never want to do that. So I don't think he ever meant to really do it. Besides, the court in Illinois can't really make any decisions on the evidence. They're there for one reason only. And the judge laid it out in his decision. He said, when you have a habeas petition, the only thing the court is looking at is, one, whether the extradition documents on their face are regular in form. Two, whether the petitioner has been charged with a crime in the demanding state. Three, whether the petitioner is the person named in the request for extradition. And four, whether the petitioner is a fugitive. And he basically said, look, 2, 3, and 4, no problem at all. We've met those. The only thing challenged by the defense was number 1, and I find that the document was just fine.
So let's take a look at what the charges are now, because now he's in Kenosha, he's in Wisconsin, and we are on track for a trial in this one. The charges: first-degree intentional homicide, first-degree reckless homicide, attempted first-degree intentional homicide, first-degree recklessly endangering the safety, 2 counts, and possession of a dangerous weapon by a person under 18. That last one's going to be kind of difficult because his age is his age, and there's video of him, and I think he has pretty much conceded that fact to a certain extent. This battle is going to be, is this homicide or is this self-defense? The video that we're looking at now, though, is after the second shooting. The first shooting, I don't know how much direct video there is of that. And that's going to come down to some eyewitness testimony. Maybe there's some videos with it in the background. Ted, how do you think the prosecution proves that one? Because if someone's alleging self-defense, you have to prove that it wasn't self-defense. So they've got to prove that it was, in fact, intentional homicide, not self-defense. How do you think they prove that?
Well, I think they will have eyewitness testimony is going to be huge in this case, along with the video. And jurors are going to be able to see for themselves that he shows up with this gun, with an attitude. The prosecutors would argue that he was looking for trouble, that he invited this trouble, and sure enough, it came.
Well, let me ask you this, Ted. How do they argue he invited this mob that is chasing him down the street, that he's running away from?
Well, because he was running down the street with a rifle, and someone running down the street with a rifle is going to attract attention, and in this case, attracted people that wanted to stop him.
He's trying to run away from him, though. He's trying to run away, and he gets hit in the head, and then he trips. Michael, do you see it differently, Michael?
I do. He made the decision to leave a group of other people, supposedly saving a business up in Wisconsin where he doesn't live. He made that decision to leave and run down the street.
Right. So as he's running, Michael, I'm interested in your take on this too. He's running down the street, and there's a mob of people following him. Someone smacks him in the head, and then he trips, and then someone hits him in the head with a skateboard.
You know, it can be seen 2 ways, Vinny. You could see a guy who's a felon running away from a crime scene, and these are folks just trying to capture this guy.
Oh, it's a citizen's arrest? Is that what this is?
This could be a citizen's arrest situation. Absolutely. He could be running away from a crime scene. You could look at it that way. Or
we all know he's running towards the police, right? Michael,
yes.
at the end of the street that he's running is where all the police cars are.
Yes. Now this, again, Vinny,
so how's that a citizen's arrest?
Oh, hold on. This is the second incident. Okay, so what I'm going to say next is he could also argue that, in fact, he was running away because even if you provoke an incident in Wisconsin, if you are legitimately trying to run away and get away from that incident, you are allowed to then invoke self-defense if you are attacked. So he can certainly paint that second situation that we see here on tape that way. But again, you can see someone who's running away, someone who earlier these protesters saw had the support of the police. Maybe they didn't trust the police to do what they were supposed to do. And we saw later on, police roll right by this guy walking in the street, actually trying even to flag them down with a rifle on him. So I don't know how wrong they might have been if they thought that. So you can look at that situation two ways, Vinny.
Ted, I want to go back to you on that. So we see where the police are. Everyone sees the police at the end of the street. That's the direction he's running. And do you think that prosecutors will argue that they were, or the witnesses will say they were trying to effectuate a citizen's arrest? We don't like citizen's arrests, right? Yeah. That's what happened in the Ahmaud Arbery case.
Right. I don't know what the witnesses are going to say, but prosecutors have charged this young man. They must have evidence, right? We assume that they have some legitimate eyewitness testimony characterizing his behavior before this video starts. And that's really the key here, because yes, the video in itself, what people have seen across the country, you could say this was self-defense, this kid was being attacked. What happened beforehand? What happened when he was talking to the police officers, when they threw him a bottle of water? We did see him earlier, but then there's this big gap. What happened from when he was with others to while he's now a lone wolf running through the streets of Kenosha, armed with an AK-47?
Yeah, I think the second shooting, I think that's a difficult one for prosecutors. The first one, you know, could be a stronger case where they don't have videotape, because then it's going to be eyewitnesses. It might put some pressure, and Rittenhouse may have to testify.
Let me ask you a quick question. If one of those guys chasing him down the street testifies, hey, the guy he shot was my friend, I'm going to try to get this guy and stop him from getting away, I mean, would that change your opinion?
Is it the guy who hits him in the head with the skateboard?
No, I'm not saying I don't know who any of those people are, who's connected to what. What I'm asking you, if one of them testifies that in fact that guy I just saw him shoot was a friend of mine, so now I want to make sure that this guy doesn't get away, and that's the reason for what you're seeing in that video. Would that change the way you see what you're seeing?
Well, what I'm seeing is a real difficult case for prosecutors. I mean, that's the way I look at it. You got to prove that that's not self-defense beyond a reasonable doubt, which means
that's the second shooting, Vinny. There was another shooting.
Right. The first shooting, I haven't seen a video. I've heard different accounts from witnesses. They produced the video, the Rittenhouse team, so we kind of know what their story is going to be. But he might have to testify to get to that story. I think that's perhaps the weakness of the defense case. Is the first shooting. I think that's the one that's going to be much more problematic, because there is no video to demonstrate some level of self-defense, because you could argue self-defense in the second shooting without putting the defendant on the stand. But I think he's got to get on the stand to claim self-defense in the first shooting, unless there's a witness who sees him being attacked and is going to testify to that. But I'm not sure. I'm not sure on that. To me, that's the more difficult one for the defense, a stronger case for prosecutors, unless the eyewitness who is, and there's people there, and one of them is a journalist, by the way. There was a journalist who I think witnessed this and may have video of it and may not. That I'm not clear on. But I think one of the first people to respond after the shooting is a journalist. So, presumably that person doesn't have any sort of horse in the race, so they're going to just testify to what they saw. And I think will probably end up being a very credible witness. And I think the whole case is going to hinge on that witness and others. Do you agree, Ted?
Absolutely. It's all about the eyewitnesses, and it's about jury selection. Let's face it, people coming in with preconceived notions either about this case or the right to bear arms, et cetera, is going to play a huge part in this case. And I agree with you. It's a tough case, but I also think that there's something there. Otherwise, I have faith in the great state of Wisconsin and their prosecutors. They wouldn't have brought these charges if they don't think they can prove them.
Yeah. Well, here's the thing with the eyewitnesses when it comes to credibility. Because it's two factions and it's a protest and a sort of counter-protest, the way it's been sort of described, Michael, is if all the witnesses are the protesters and they're testifying against the counter-protester, not as strong from my perspective as an independent journalist who is there and seeing things just to observe.
Yeah, that independent journalist is going to be extremely important, Vinny, at the end of the day, because like you said, everyone has sort of a stake who's at that protest, right? They're sort of anti-police, so they're going to come in and they're going to play up that point. If they do, in fact, take the stand, cross-examination is going to be difficult for those individuals. But again, you look at these charges and they came with intentional murder. And again, I'm not sure I see that in the tape that we've seen most played, and we saw a little bit of tape of the shooting of the first one. But to charge intentional murder, they must have something from that first shooting that leads them to think that that's the right charge. At least I hope they do. I hope they're not deliberately overcharging here. But if they charge first-degree murder, intentional murder, they must have something, and they must have someone they believe is credible.
We shall see. Ted Rollins, thank you so much. Michael's got to do overtime with us. He's coming back in just a second.